Mesanso Emma obi biara akwaba biom e de ba ye channel yi eso busua munya subscribe ya mesere wo no subscribe no like no share video yi e de amaye na bibia etimi akoyi na wa share so e de amaye na chese abusua nsɛm ahorow a na kyerɛ sɛ ɛnam internet wei so no na kyerɛ sɛ ɛho yie paa na kyerɛ sɛ NDC amanyɔkuo wei na ɔmo ate ekuo bi a ɔmo kyerɛ sɛ adeɛ a ɔmo de saa kuo no ɛhwehwɛ ɔmo a ɔmo susu sɛ aban sika akɔkɔdi ɔmo nkyɛn anaasɛ aban biribi no akɔkɔka ɔmo nsa ɛwɔ sɛ ɔmo gye no ɛno ɛna ɛho nsɛnsɛm aba bɛtɔ mmɔnten so na ɔmo kyerɛ sɛ NDC nominee baako etimi ɛde aban sika no asan akɔkɔpiem ɛwɔ court a na te sɛ ɛnya asɛm ketewa koraa wɔawie sika no de akɔ akɔhyɛ judge no sɛ ɛyɛ judge no mmom ɛna ɛwie sika no a ɛnam ɛno nso nti no ɔmo ba abɛto aba na ɔmo hu sɛ ɔmo bɛyi saa judge wei de afi ayɛ akonnwa no so na ɔmo de obi esi so anaasɛ ɛnyɛ saa na ɔmo nhu de ayɛ asɛm no nkasa no ɛkɔ akɔwie na mesɛ ɔmo no yɛbɛkɔ ne akɔ akɔgye asɛm wei emu nkyerɛmu no yɛba a ɛde aka nyinaa aba bɛsɔ so meda wase.
To the effect that Chief Justice can act as a president. What, on the basis of which provisions did that come up?
Thank you. It was by Professor Kruje in the case of Asarabes Attorney General, which I personally, even though it is an arbiter, I disagree. Because if you are interpreting, you must interpret within the context, and you must be fair. You must be fair to the text. Faithfulness, that is cardinal principle in interpretation, faithfulness to the text, where it has not been stated anywhere. But I do not blame him because he was discussing the position of 1960. Sense of the government. He used that one because '57 is different from 1992 Constitution. So at no point in time can you compare the two. So if you look at, he was influenced by that position, but within the context of the Constitution, it cannot be so. Thank you.
Is it desirable in the context of separation of powers to ever place the head of the judiciary as the head of the executive?
No, please, because we had one in 1957 which brought about Stowell will travel to England, and the Chief Justice was signed to make him unpopular. So it is not advisable to use the Chief Justice as one of the to exercise one of the executive powers. It is not advisable. Thank you.
Because within the context of separation of powers, if the person who is the arbiter becomes the actor, how do we resolve misconduct by that person or wrongful conduct by that person that gets contested in your court?
Thank you. Thank you, Honorable. It could be a bad practice because why do you involve a judge or Chief Justice whose role is resolution of disputes, which is different from the role of the executive? If it extends to Parliament, there's nothing wrong because they are politicians. They were voted for. They put up their campaign, and at the end of the day, they were voted for. So they can act. But where the Chief Justice, you are supposed to be independent, impartial, and you are to go and perform executive function, it will violate every principle of rule of law. Thank you.
Now, looking at, I think you, from your previous answers, you seem to me as a judge who has some belief in the purposive approach to constitutional interpretation.
I have several publications on it. Thank you.
So you endorse purposive interpretation?
But leader, so I take it that you are now having your turn.
My turn.
Very well.
You endorse the purposive approach to constitutional interpretation.
That is so.
Now, Article 60 talks about two scenarios: absence from the country and inability to perform your functions. From a purposive approach to interpretation, in this era where absence from the country is not the same as inability to perform your functions, in view of developments in telecommunications and etc., where you can even sit abroad and then chair a cabinet meeting, where you can sit abroad and receive briefings. In fact, on your aircraft, you can actually chair a cabinet meeting taking place in the Flagstaff House. So on a purposive interpretation to our Constitution, given that the Constitution is anticipating absence from Ghana based on an assumption in 1992 that when you are physically absent, you will not be able to exercise your function as president, or where you are actually here but you are unable to perform, maybe due to ill health or some other consideration. Given that that is not really something that practically exists now, can we say that at any moment a president is absent from Ghana and as a result unable to perform his functions, by which reason, you know, when both president and vice president are not there, there is a fundamental breach of the Constitution?
Thank you, Chair. When we talk about unable to perform his function, and it is outside or he's outside the jurisdiction, and if you look at the decisions rendered by the Supreme Court, the one against Honorable Ajaho, the Supreme Court said that no, the person must be physically present in Ghana. That was the intention at the time the law was made, because we were scared of soldiers, that at the least the soldiers will come. And therefore, as a commander-in-chief, if you are not there, somebody should take over from you. And as I said, when we take into account purposive interpretation, what we do is that we look at the law. We look at having looked at the law, then the next thing that we do is we look at the context within which it was made, context. So having taken it out of the context, then we move to the second stage. We look at the purpose, the subject matter, the scope, and to some extent the background. What informed that? The background, does it still prevail? So I believe if there is a new application, nothing will prevent the Supreme Court may take into account technology, development, and move to different level. Nothing may prevent it, because if it is to be construed purposively, then whether the president is in Ghana or not, provided he's not sick, he's not seriously sick and can perform his function, I don't think this should be a critical issue. Thank you, Honorable.
And can you reconcile a situation where the president is attending the United Nations General Assembly on behalf of Ghana in his capacity as president? He's there in his capacity as president, sometimes even on a state visit in his capacity as president. And then in his absence, the vice president is sworn in as the acting president. At that time, do we have two presidents for Ghana? The vice president is acting as the president. Yes. So the point I'm making is, do we have one president acting outside Ghana and another president acting in Ghana?
Thank you, Honorable Chair. Honorable Chair, that is why from the beginning I said that there is an issue with that decision, but it is binding on everybody until it is varied or set aside. But as you know, Supreme Court decision can change at any time, provided it is policy, such as this one. It can change at any time. That is why we say that it is a living organism capable of growth. And in the case of Zenita Lawrence, Dasatuguba openly stated that because of modern purposive approach, meanings can change at any time.